Hi, I'm Maya Berry. Welcome to Viewpoint. The Senate Judiciary Committee is hearing testimony from privacy and security experts on the pros and cons of authorizing a law known as Section 702. The law allows U.S. intelligence agencies to collect electronic communication of foreigners living outside the United States, and also collects a huge amount of email, text, and other personal data from Americans in the same process. Joining me to discuss this latest government surveillance debate is Drew Mitnick. He's Junior Policy Counsel for the digital rights organization Access Now, where he works on cybersecurity, digital due process, and privacy. Drew, thanks so much for being with us today.
Thanks for having me.
So before we jump to the conversation on 702, and actually I think it's partly directly related, one of the biggest issues with regards to the conversation about surveillance is the inability of sort of your average citizen to understand why this impacts them. So you can start a bit with that, please. Yeah,
I'm happy to. And you know, I think part of the struggle is when you have names like 702, what does that really mean, right? We don't know anything. And so we've seen words like PRISM and upstream thrown around when talking about it, but it really is difficult to connect that with our everyday lives. But when we're talking about surveillance under these programs, we're talking about the potential capture of the content that we express online, so the speech that we put online, so our communications, it could be with our loved ones, with our friends, with our confidants. Under 702, it's going to be primarily with those outside of the country, and so for those of us that have strong relations with people outside of the country and we talk to them on a regular basis, that's going to be the type of information that's implicated. And so you can see once you kind of paint a picture of all the programs that are operated, 702 and the others, you know, you start to gain insight into the fact that they have access to content. We're talking about the government has access to the content, and also metadata, which tracks our daily movements potentially. And so it's a very comprehensive illustration of what our everyday lives look like.
So for a person who views this in the context of, hey, if I'm not doing anything wrong, what's wrong with the idea that the government needs to keep an eye on things in order to make sure that we're all going to be safer because they're catching the bad guys? I think that's a part of this that was changed a bit by the Edward Snowden information, but not necessarily broader. If you can speak to that piece.
Yeah, of course. You know, so I think there are a couple ways to approach that conversation. I'm not doing anything wrong, so why do I care about privacy? And the first thing I would say is that we all have things that we don't want exposed. And when the government is collecting our personal information, there's a risk that it will be exposed more widely. So intimate conversations with our friends, we might say things that shouldn't naturally be out there. But let's think about the fact that now our healthcare information is posted online. So after you visit a doctor, that information might be posted to an online portal. And that information is potentially susceptible to collection. And once it is collected, then it can be used for all kinds of nefarious purposes if it gets in the wrong hands. And so by simply creating these programs, you're creating a process where this information could end up in the wrong hands. And I think beyond that, if you think about traditionally how surveillance programs have been used in the United States and continue to be used internationally, you're talking about potentially targeting vulnerable communities. And so even if you yourself are doing nothing wrong and have very little risk for surveillance, I think the people that deserve the most protection are those that are most likely to be harmed by these programs. And it often has a chilling effect. So if personal information is collected and we're aware of it, it would chill our ability to express ourselves. And so those communities that are most vulnerable are going to be the most likely to end up having their freedom of expression chilled.
Let's go to Section 702 now. How did we get to the point of the hearing this week in terms of the debate on the subject matter?
So this was a law that was passed initially in 2008, and it's been reauthorized a couple of times. The FISA Amendments Act. As you mentioned, it specifically targets information on non-U.S. persons, but as that information enters the United States or exists in the United States. The programs authorized by the law were revealed by Edward Snowden. And so this is the first time next year when the program is up for reauthorization. This will be the first time we really had an opportunity to assess what those programs do and evaluate whether we think that there are adequate human rights protections. And so the two big programs that we're now aware of are PRISM, which is a program where the information is stored on the tech companies' servers, so thinking about the big ones like Google and Apple, and the government has ways to access that information. And then upstream, which is as the information transits into the United States through undersea communications cables, that information can be queried using specific terms. And so in both instances, you see a tendency toward accessing, broadly being able to access information with very few limitations. And it's done under the name of foreign intelligence, but ultimately it really includes everyone because, as you said, Americans are implicated as well. And so I think there are a couple questions which the organization that I work for asks, do these programs abide by human rights protections? Are they necessary and proportionate, are some of the questions that we'd ask. And I think when you're talking about the ability to run selectors against nearly every piece of data that enters the United States, there's at least a significant question as to whether it's proportionate surveillance. And then you can also ask whether, under the Fourth Amendment of the U.S. Constitution, whether protections for Americans are adequate. And so we have what's called backdoor surveillance of Americans, where individuals who are potentially communicating with those abroad, even though they're American, they could be targeted, and that information could be subject to surveillance under those programs.
One of the things in the aftermath of the attacks of 9/11 was, of course, the passage of the Patriot Act that began the process of putting all of this in place in terms of responding to this. Some of those provisions had sunset clauses put in there on purpose, with the idea being that we would examine all of this after the fact to say, did we strike the right balance between meeting civil rights, civil liberties protections, and national security concerns? What is the current sort of take on that particular balance piece, particularly with regards to Section 702?
Yeah, so one of the challenges with having sunset clauses is they're only really effective if we know how the law is being used, which we didn't until the Snowden revelations. And so part of the conversation happening now in the hearings on 702 is whether there's adequate transparency in the programs. And I think evaluating the transparency is one of the initial questions we should ask in assessing whether, whether the programs are properly administered. And that's fine, and I think we should have that conversation. But I think beyond that, then you get to the point of having a conversation about the substantive limits and hitting on those protections that I mentioned, the Fourth Amendment protections and the human rights protections. So I think specifically thinking about 702, a lot of that conversation is about transparency. There was an effort to broadly reform surveillance post-Snowden. And that was part of the Patriot Act that enabled the collection of telephone metadata. And thanks to broader knowledge of how that program worked, we were able to place some limit on the collection. And that's a program that enabled the collection of nearly all American cell phone records.
So in terms of the hearings this week, what in particular brought you some hope in that there are members of Congress that are looking more critically at the state of surveillance in the U.S.?
Yeah, you had some members that spoke up effectively in protection of civil liberties and human rights. So you had Senator Leahy and Senator Franken, and they, I think they talked a lot about transparency, and they talked a lot about protections for Americans. And those are, and as I mentioned, those are really key elements of the debate.
In terms of having this conversation, and again, I feel like it tends to happen at a level that gets missed by most average Americans in terms of this. Can you explain a bit about how this really is, in some ways, a warrantless search, that's part of what's happening here when they're able to pick it up from the massive metadata piece, just so that I think an average person understands how this connects to them.
Right. Yeah, generally the way that a warrant would work is that you would go to a court and say, I have this individual that I'd want to conduct surveillance. So there's specificity involved. The challenge with 702 programs is that the intelligence agencies go to the FISA court, and they get authorization to broadly run the programs, and then the oversight is conducted within the intelligence agencies themselves, with limitations on the collection. Limitations after the collection. So there are a few limitations on the collection itself. That's not traditionally how warrants have worked. And the justification is that you don't need a warrant because it's a foreign intelligence context. But when you're talking about the surveillance of U.S. persons as well, when backdoor searches are included, I think that's a bit of a misleading argument, and it's a new application that we haven't seen before. And so I think now that we're having a public discussion, there's an opportunity to really address whether the existing protections are adequate.
So I recall during the time that the Edward Snowden piece actually broke, there's the interview that he did with Wired magazine, where he talks about in his own progression and his decision to become a government whistleblower. One of the pieces was specifically information that had been shared with a foreign government about Arab Americans. He actually talks about information specifically that was caught up as part of this program on Palestinian Americans shared with the government of Israel, and without it being scrubbed, so that it actually included information. It would have been my name, that kind of a piece. The issue of this data, once it's out here and part of our surveillance programs, and how it's shared with other entities. Can you speak a bit to why that should, I mean, it seems obvious in some ways why that should concern us, but why that should concern communities like ours, but broader than that as well? Yeah.
So, one of the questions I think Senator Leahy asked when thinking about this, the new debate about 702 is, and I think we've actually seen, so the Privacy and Civil Liberties Oversight Board has raised this before. I think it's been raised a couple of times. But these selectors that we're using to query the information as it enters the United States, there's not a lot of control over to how broadly they can hit. And so you're talking about a potentially significant amount of information about a fairly wide-reaching. So thinking about particular regions where surveillance is going to be targeted most heavily in the Middle East, and then those individuals who have the connections to those countries are going to be the ones who are going to be subject to most of their information being actually queried by the intelligence agencies. And so one of the questions that's lingered over this conversation is, once the NSA collects that information, what regulations are in place to limit that sharing to, say, the FBI for domestic criminal law enforcement? And there is not as much as you would hope. I mean, there are some limitations, but they're narrow. And so we're seeing, for example, we saw the Drug Enforcement Agency be able to query pretty extensively the information that was collected for foreign intelligence purposes. And we're seeing it used, I think, to a degree on a more narrow level, but thinking about certain Muslim and Arab communities. And so I hope what becomes more part of the conversation is how that information can be used to discriminate against individuals and how that affects their lives more so than, say, just an average American person.
You mentioned the Civil Rights and Civil Liberties Oversight Board. Those are protections that were put in place specifically to look at these policies. They've made some recommendations. How much of that has, I mean, Congress plays their certain oversight role, and these hearings are an important part of that. But how much weight has this board had in this process? How much have they been able to push back on some of these policies?
So far, their recommendations on 702 in particular have not, to the full extent, been implemented. And they were, I would say that they were not very extensive, sweeping reforms. I mean,
that was going to be my question even before that, is how much of their recommendations actually address the problem in a holistic way to begin with?
Right. I mean, I think if the question is, the way we approach it is, are these programs actually targeted surveillance programs, or are they mass surveillance programs? And if they're mass surveillance programs, that's likely a violation of human rights. That's not the approach that, for example, the Privacy and Civil Liberties Oversight Board took in addressing 702. I think they looked more at some of those back-end limitations and some of the narrowing of the selectors, which are fine questions, but I don't think that gets to the broader issue, which is compliance with human rights and the principles that we've, as a nation, signed on to in ratifying human rights treaties. I don't think we've really done the analysis to the degree that it should be done as to whether these programs are in compliance. And the PCLOB, for the good work that it's doing, it's still a political body. it's divided between Democrats and Republicans, and it's designed to a degree to create some tension within itself. So there's only so much it can accomplish as an oversight body.
So the hyper-partisan nature of Washington and Congress in particular is pretty apparent. One of the few areas where I think people tend to be hopeful about sort of bipartisan concern about policies comes in play with regards to surveillance. Mm-hmm. How have you found that to have played out in terms of pushing back against the Democratic administration that's been in charge and asking for some of these policies, and frankly, a really active libertarian right sort of coalition in Congress that's attempted to sort of push back? We saw that with the USA Patriot, the USA Freedom Act. Yeah. Has that helped in this process?
It has helped. Yeah, I think it's nice to not have to rely on traditional strict party institutions for advocating for reform. Mm-hmm. And so it is nice when you have both the left and right coalescing. The problem, I think, is that far too often it's still viewed as fringe to want to put privacy protections in place. And so, as an organization, we're nonpartisan, we're a global organization, so we don't align with either political party. And we certainly work we strive to work with all sides, with all communities. And you had candidates like Ted Cruz, who at one point was supportive of certain elements of reform for surveillance. But
it was interesting because it was used in the campaign in a very sort of negative way, actually, yeah. That he was shutting down the surveillance program, didn't allow for us to better protect ourselves from, these terrorists. I mean, the idea that's so profoundly American, this right to privacy, in some ways isn't viewed that way, I think, by a lot of average Americans on this subject.
You certainly have institutional politicians who are aggressive on national security, and they view any limitation on a national security program as a betrayal of our security. And I think without really examining whether those programs are run effectively, I think there's oftentimes overlap between the questions of privacy and efficacy, and we saw that with Section 215 with the telephone metadata program. Explain that a bit.
Section 215.
So this was the program that it was a program that was operated under 215 that enabled the collection of all cell phone metadata. So it included things like the cell phone numbers, the time between conversations between two individuals. It was just about all of that information was given to the government, and so the question was whether the government needs all that information or whether they can use some existing intelligence to figure out who they should be targeting. And so there was a reform effort. It was successful, as you said, the USA Freedom Act, that does require the government to now provide some specificity in accessing those metadata records. So, it goes to show that there can be success. I think part of the reason that reform effort was effective is because it was specifically geared at Americans, and so it was a little bit easier as a politician to sign on to a U.S.-focused program as opposed to reform of FISA we're talking about now, which does implicate a lot of non-Americans, but also, as we've said, a significant number of Americans are in there too. So.
Right. I know that one of the sort of next big fronts at which we will see surveillance issues come up is Rule 41.
Yeah.
As you said in the beginning of the show, these have incredibly easy to forget names.
Yeah.
But tell us a bit about Rule 41 and why it's an important piece of the debate coming up.
Right. So we saw in the San Bernardino iPhone case that the FBI was attempting to gain access to an encrypted iPhone. And so one of the questions beyond just the use of backdoors to encryption to gain access to that information is whether the government can hack devices. They can use their own techniques to gain access to a device that don't rely on weakening the encryption necessarily. And so Rule 41 is a rule of criminal procedure that would allow law enforcement to go to basically any court to get a warrant for hacking, even when the location of the device is not known. And so it would be for an investigation of like the criminal hacking statute. The problem, though, is that we're now talking about the procedure for government hacking, about the use of hacking techniques, and we've never had a conversation about that in Congress. There's no authorization. There's no specific authorization for hacking that's been legislated. But now we're talking about a procedural rule that we're potentially expanding without I think having that first conversation. And part of the problem with the broad use of hacking is that there are sweeping implications. So if the FBI were to use an investigative technique to get into a device, that technique could potentially spread to a number of other devices. There's a significant risk to using these devices. And you're often talking about investigating victims of hacking crimes, and to get into the victim's device to do some investigation. And so I think that there's a lot of question about appropriate limitations that we haven't had.
And presumably the idea that we are going to be hacking this equipment, even the term that's being used, would suggest that the technology companies are not cooperating with government requests to provide this data. That was a pretty significant issue as part of the campaign as well, with regards to specifically the San Bernardino case. How is that impacting the policy discussion on this, particularly with members of Congress who want to position themselves as, in one place or another on this?
Yeah, we've seen an array of positions, and we've seen some members of Congress, Senator Wyden, Representative Liu, who've come out and said we need to have a legislative limitation on forcing companies to undermine encryption, which, there are all kinds of arguments against undermining encryption. We've seen so many examples where undermining an encrypted device just spreads the vulnerability, spreads the encryption vulnerability. We've also heard a lot of politicians who have come out and said we should, for example, boycott the companies that use strong encryption, that stand up against government mandates. And so it's going to continue, I think, play out, and I think it's good that we're having the conversation, and hopefully it comes out on the right side ultimately.
How do people understand this in the context of companies or providers who literally said now it's a way of branding their product that you can get around the encryption piece, the WhatsApps and the others? I mean, clearly there is a sense that people respect their privacy in this context and are looking to protect it. How have the tech companies been coming in on this issue?
I think that's one of the clearest signs that people do care about their privacy, is that we've seen a proliferation of encrypted communication channels that we haven't really seen. We haven't seen that previously. So you mentioned WhatsApp. The way that these systems are being implemented now is that you can have a conversation with a person who also uses the same encryption communication, and it's protected from either a malicious attacker in the middle or a government accessing that information. And so you have all kinds of governments around the world that would love to gain access to it for nefarious purposes and sometimes legitimate purposes as well. So now that we're seeing privacy marketed effectively, I think that should be an indication to politicians that people do care about their privacy. And I think you also have to emphasize that it's not just a privacy issue too. It's also a security issue. It's going to be the future of these debates is going to be a combination of how does this impact our privacy, and we're talking about ensuring government access to secure communication, but also what does it mean for our digital security? What does it mean for the healthcare records that I mentioned earlier, and whether we're actually protecting those records? So I think only more so, people are going to recognize the value in buying services that offer that kind of protection. The Internet of Things is going to be the future, as we've heard said endlessly.
I mean, it's particularly the case given how much data there is. I mean, it's incredible to think about what we walk around with as our cell phones alone, so much as how much of our information is available online. I mean, the point being, if there was a time to be concerned about this, it's absolutely now because of the prevalence of this information.
That's right, it's now, and I think now's the time to ensure that there are those protections. If we go too far down the rabbit hole and we don't ensure that we have digital security protections for all that data we're generating, then we're creating significant risk for ourselves unnecessarily.
We are in the middle of a pretty intense presidential election cycle. There are times when the candidates say things that are helpful to advancing people's policy understandings of issues, and there are times not so much. If you were able to ask, in a debate question, or if you got to decide these guys weighing in on this issue, what would you want them saying as part of our national conversation on important policy matters on the issue of surveillance?
Yeah, I'd like them to recognize the value of individuals being able to protect their own privacy. It's far too often when they talk about privacy, they purely talk about it in terms of national security. When they talk about security generally, it's only talked about in terms of national security, and that's an important conversation to have. But I would like a candidate out there also to recognize the value of human rights protection, the value of privacy, and the value of individuals' ability to secure themselves.
And members of Congress on this as well, in terms of, we've talked about Section 702 and Rule 41. What do you expect to come down further down the pipe on these?
Yeah, so the Internet of Things is going to continue to be an issue that we're seeing a little bit of regulatory action on. And I think there's going to be more of it because there's a recognition of the level of data that we're collecting and how to approach it. Government hacking, so I hope beyond Rule 41 we have an actual conversation about appropriate use of hacking. Another question is, when the government finds a vulnerability, like they did for the San Bernardino iPhone case, what is it?
You mean by vulnerability? You mean the ability to actually use a backdoor to get into that? Okay.
One of the questions pending from that instance was, now that the FBI had the ability to gain access to the device, did they give that vulnerability to Apple to better protect iPhones? And the FBI said that they can. It's part of the agreement with the company that provided the vulnerability.
That they cannot provide it. They can't share it back.
Share it with Apple. But there should be, it needs to be part of the conversation as to whether they should share that vulnerability, because it would protect iPhone users around the world. So that will continue to be, I think, part of the conversation going forward.
This idea that it's not about just a company and this provider who hacked it for them effectively, that these are bigger pieces.
It's about the
common good. Yeah.
Yeah.
Does, in terms of trying to, I keep going back to sort of the layperson explanation of this. How much of a priority is this for members of Congress as they reflect on? I mean, do they hear a lot from constituents on these issues to the point where they will weigh in and try to sort of take a risk to push this envelope a bit further about affording better protections?
There are certainly members that are responding more effectively to the advocacy on these issues. And I think and hope that after seeing the response to things like the San Bernardino case, there will be greater recognition. So, we have seen some progress recently. So, a separate law that enables access to information stored in email servers for more than 180 days, where the government can then access that information without a warrant. The House of Representatives actually just passed a reform bill that would require warrants for access to stored email information. And so I think that's a response to partially the broader recognition of the privacy issues when we're talking about digital technology. So I think I think that the fight over the email stored email data is indicative of hopefully a better future.
Thank you, Drew. Thank you for the work that you all do and for taking the time to explain it to us today. That's all the time that we have. For more information, follow us on Twitter at AIUSA or check out our website at aiusa.org. Thanks for watching, and we'll see you next week on another edition of Viewpoint.